Welcome back. You are still on Smart Money with Emmy Hernandez, with me right here. In the last segment, we talk about power of attorney for healthcare and for financial management. Remember, I told you that power of attorney, it's good when you're still alive, but these power dies with you. So when you die, power stop. So your next question would be, uh-oh, so what do I do now? What would happen to my asset then after I passed away? Well, then we're going to talk about the next set of document that's important to you that you must have. You probably want to consider to have a will and a living trust. What are they? Let's break it down. A will is actually a cornerstone of your not financial, I'm sorry, for your estate planning. Because when you have a will will be an instruction of how you want your asset to be distributed when you're no longer here. It will give you an authorization that you will put on that, for someone that you name as an executor. Okay, we use terminology an executor for the will because that person will represent you, will be on in your position to distribute your asset. That person will know exactly which go to whom, where, and when. You lay it out on your will, and you can even give an instruction of what to do with your body as well. What you want for your funerals, things in that nature. You can put it all on in the will. Now, with will though, even though it's a cornerstone piece of your estate planning, sometime when you talk to an attorney, they may say that, hey, you know what, will is not enough. Maybe you should have a living trust or some type of other document to go with that as well. And the reason behind that, because when you have a will, yes, it gives an instruction, it prevents fighting in your family, but the drawback of will is that generally most will must go to probate. What is it? What is probate? Probate is a court procedure that the attorney or your representative have to take your will and file at the court and wait for the court date because the judge have to go over and review your will and they have to put a stamp on it and say, okay, this one is valid, it's validated. Now your agent can have the power to go out there and do the distribution for you. However, as you know, anything that go to court take long time. So when you have a will, it can take months and months or sometimes even get up to years depending on how much asset and what type of asset that you have in your estate. Okay, so will can take long time because you have to get onto the court calendar for that. So with that, when you involve court and attorney, you have fees involved as well. So probate fees is normally a statutory fees. So what's that mean? Statutory fee meaning that you cannot negotiate. It's a set fee. And in general, in California, probate fee can be anywhere on average about 5 to 7% of the fair market value of your estate, the total gross estate. We talk about gross estate before we deduct any mortgage or any liability that you have. Okay, so when you looking at that fees and time consuming, wow, that can cost a lot of money. So maybe will may not be enough for that. Okay, even though it will help, but it might not be the best choice for you. So now, if you have an asset and you want to pass it on to your beneficiary without probate, what do you do? In that case, you might want to consider a trust instead of a will. What is a trust? A trust is actually a legal contract. A legal contract that you set up between you, a grantor or a trustor. You set up a contract, you're drawing a document that we call trust agreement, or sometimes people call a declaration of trust. They're the same thing. You set it up, you have a document, and you set up a contract for you as a trustor and the trustee. The trustee, when you're alive, the trustee is the person that manage your affair or your estate. Okay, so when you're still alive, you can be both trustor and trustee. But you will name a successor. You will name a person who next in line, when you're no longer here, that person will fit in your shoes. They take your step and they become the trustee and take care of your affair. Now, because of A trust is a legal contract. If you execute it properly, it will become valid and it have long life expectancy beyond you. So when you passed away, your trust still alive. With that in mind, you don't have to go to court. Your beneficiary no longer have to go to court. The trustee can just go in and step in and take care of the asset distribution for you. And the trust is a contract that you set up for a person, a trustee, to manage and distribute the asset that used to belong to you for the benefit of your beneficiaries. So you can list many people as possible as you want in the trust as your beneficiary. And not only that, a trust document is very flexible. That's why we call it living trust. Because you, as long as you're still alive, while you're still alive, you can amend your trust, you can change it, you can even revoke it. If you don't like it anymore, you can revoke that trust, write up a new one. So it's a very, very flexible documentation that you can have. Even if you have just one property in California, I want you to start considering having a living trust. The reason is, for example, if you have a house here in California, we're talking about at least, perhaps maybe your value of your house would be like about $300,000. A $300,000 estate, if you have to go to probate, the probate fees will start off at 4% on the first $100,000. So after all, we go with the gross value of the estate. Okay, it doesn't matter whether you have mortgage on your house or not. So then your probate fee can start from that point on. You can see that it already can cost a lot of money. So living trust can help you avoid all that. So living trust, as a recap, it's something that you should have because it helps you settle down, give out the instruction, who will be your beneficiary, who will get what you want to distribute at the end of your life, who get what in an orderly manner, and it's timely because it avoids probate, and it's very cost efficient since you don't have to pay all those unnecessary fees. Okay, so as we talk about here, will and trust should be a cornerstone pieces of your estate planning part. As a financial advisor, I'm here to help you. So if you have any questions or comment, send it to me by email to emmy@ehfinancial.com. Don't forget, if you miss any part of the show, you can watch us again on ehfinancial.com or crowncitynetwork.com. Remember, being smart with your money is easy, and you can do it. Thanks for watching. See you next time right here on Smart Money with Emmy Hernandez.